it's so important if you're a board member, and to your point, ignorance is not a defense.
Right.
That these laws, sometimes they think the end all be all is the CC&Rs.
Right.
This is what it says. But this now, your CC&Rs in this regard are null and void, and for those particular provisions.
Right.
Because state law now overrules it. I think it's so important for board members, and hopefully they've got good management company and counsel that tell them this, because they could cause some serious problems just by being ignorant of it. So
100%.
I hope the HOAs, I hope the good HOAs, and I hope any HOA adheres to this and understands what this means for homeowners.
I'm Luke Carlson, and for almost 2 decades, my law firm, Ellis Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of Bad HOA. Welcome back to the podcast. Marty, happy 2026.
Happy 2026. It's hard not to reflect on the past year when you think about going into 2026. And my gosh, did we do quite a few episodes and did a lot of cool stuff last year, which I'm excited about. But this year we have even more ambitious projects, which I'm really excited about.
Yeah, and listen, we're rolling them out. If everyone's following the subreddit, they see all the new tools, empowerment kits that we're rolling out, which is very exciting. And it seems to be getting great traction.
I was just about to say, I'm so pleased with the subreddit, actually. We kind of designed it to hopefully be a hub for the content and for homeowners to take what we have and kind of discuss amongst themselves and say, hey, this worked, this didn't work. Have you thought about this? And really make an avenue to have self-help, right? And it took off way faster than I even imagined. There's been a lot of activity on there, and we've generated a lot of new podcast episodes because of people posting in there. So I'm really pleased with how that's going. And I think the most rewarding thing, and I've seen it time and time again. Yesterday I saw, I wish you practiced in here, but I've watched all your episodes. Thank you for what you're doing. And I'm like, oh, that's really cool. We've seen real people solve real disputes with some of this content. I think that's the most rewarding thing about it all.
I second that. And what also I really like too, and obviously we follow all of the subreddits involving HOA.
Yeah.
And there is such a clear distinction between most of them, right? A lot of it is just whining, complaining, and
which is fun. It is fun.
It's very entertaining.
Let's call it as it is. It is fun. It is fun to complain, and it's fun to read.
Right.
Because these are, to your word, dumpster fire.
Right.
And it's hard not to turn away.
It's shocking. It's a train wreck that you're looking at. And
you can't turn away from that car accident.
Yeah.
When you hear it, you're turning towards it.
Yeah, but it's somewhat a breath of fresh air, though, to see the empowerment of Bad HOA, where it's very much solution focused.
Right.
It's more tactical. It's more, hey, this is horrible. We recognize that this is a bad situation, but ultimately, here are some of the things. This is how I would approach it, and I'd love to see that.
And it's fun to see people kind of get their bearings. I think at first, because there's multiple HOA subreddits, as you just said, mostly bent on putting up how bad the HOA is.
Right.
And people started reposting those things in our sub, and then all of a sudden that kind of disappeared, where it's like people are looking for real solutions to real issues,
right.
and having the community be a part of it. Have you tried this? Or even some of the content that we've put out with the strike method and the homeowner empowerment kit and things along those lines, where we can keep this as a hub for people to download. And the other thing that is that, again, we're doing it for free, and we're not asking for email addresses. We're not asking for, hey, give us your content, sign up for this newsletter and get it. It's like, here, no, it's just, we put it out to you. Hopefully you get some use out of it. And I love seeing people that said, I did this and it worked. That's fantastic. So really pleased with that so far.
Well, So let's talk about 2026.
Yeah.
Right? Because this
Perfect lead
episode,
in.
Yep, perfect episode for the first episode of 2026, and it is new laws in California. I mean, it's California specific.
Yeah.
I'm a California lawyer.
Yeah.
And so we're going to go over real awesome changes in my mind to 2026. Now, again, as we looked at AB 130 last year and sort of the impact of that and this tipping point, we both acknowledged the tipping point in Sacramento.
Yeah.
In my mind, in my assessment of this is moving in the right direction. These new changes.
You know, I'll just say that even if you're not in California, we've had Jeff on, and he talks about Florida, and we're going to be doing another one of those episodes.
Yeah, Jeff, the managing partner of our Florida operation.
So we'll be doing another one, 2026, in Florida laws, and Florida has really made a lot of changes. And I see California taking like bits and pieces, like, I've seen those. I've seen those before. That in Florida as well. And I've also just, again, not being a lawyer and just on the periphery and seeing in the subreddits and things that other people are putting together. Other states, however, are seem to be passing laws as well. This is. I feel like we are on the precipice of a real change and real movement that's happening, and I hope that it comes down at a national level at some point.
Well, it's in the zeitgeist, right?
Yeah.
10 years ago, 15 years ago, it was discussed at dinner parties how bad your HOA was, right? But it was almost this concept of like, okay, we'll deal with it.
Yeah.
You're stuck with it or move.
Yep.
That has shifted.
Yeah.
Education has shifted. Access to resources has shifted. Information is becoming much more prevalent. And now it's empowerment. And I was going to talk to you about this. This would be a funny ad, or some sort of thing that we could do. It's, you have whiny homeowner crossed out instead of empowered homeowner.
Yeah.
Because really, at one point in time, though, these homeowners were viewed as just whiny and they had to take their medicine.
Yeah.
But that has shifted.
Yeah.
That's the paradigm shift right there. It's an empowered homeowner.
Yeah.
What they're complaining about, what their grievances are actually legitimate.
Yeah.
And maybe historically trivialized by the board or the board's attorneys. Now that industry is waking up.
Yeah.
And in my assessment, Florida's waking up. California's waking up to the realities.
Yeah.
So I think it's wonderful.
Yeah, indeed. Well, let's jump right into it. There's several that have taken effect as of January 1st.
Yes.
So we are right in the heart of it right now. So I'll go through it and we'll get your take if you don't mind. Let's start with SB 410.
Okay, I like this one.
Mandatory disclosure of balcony and structural inspection reports. Effective January 1st, applies to HOA homeowners buying or selling property, but primarily condominiums. All right, what the law does requires HOAs to provide copies of the most recent exterior elevated element, otherwise abbreviated as EEE. Doesn't government just love acronyms?
Absolutely.
EEE inspection reports to homeowners and prospective buyers during escrow. These reports are now a mandatory disclosure under California Civil Code 4525.
Yeah.
Really interesting. Let's get your take on it.
Well, it's a game changer. Historically, HOAs love operating in secrecy. They don't like transparency.
Yeah.
And this forces the issue so aggressively. And we always say, if you're a homeowner or you're about to buy, do your due diligence. And sometimes, especially with this type of report, it was hard to get. It was hard to secure, especially if you were on the outside looking in.
Yeah.
And if you think about it, these balconies, if there's negligence surrounding a balcony, right? If it's poorly maintained, that is such a risk to life and limb that it's massive. But HOAs were like, yeah, we don't have to disclose. We'll keep it under the rug. We'll sweep it under the rug.
Yeah.
But this is bringing it to light.
I mean, you've got and this is primarily with condos, but you have a balcony on a multi-story building.
On the 18th floor, for example, right?
I mean, you got kids or whatever. I mean, that's already scary enough to have a balcony on a high level like that. But to know that it's possibly decaying in any sort of way, like you're going out literally on a limb here. Right. So to make sure that owners get visibility on things like, says here, dry rot, structural decay, waterproofing failures, deferred maintenance. I think that's and they attach it to the sale of a home. Like mandatory disclosure. If you're selling a home, this has to be an inspection report has to be provided.
Right. And so what you're really doing is now a buyer comes in, they're educated, they know what's going on, but it also allows the actual homeowner to get access to those reports. And again, I've seen historically homeowners will say, hey, I know they ran a report on the balcony. I know they've assessed this because it's a common area.
Yeah.
Right. And so, but the issue was they weren't turning it over. I sent out many requests for it. They refused. They're stonewalling me. This is a critical report.
Yeah.
And so this, again, it really forces the HOA into the light.
But it's also not just like common areas, but if you think about it, multi-story condo buildings, you're talking if there's a balcony off of someone's homeowner
exclusive use common area.
Right. Okay. Yeah.
And so it's technically
sorry, but I'm like, hey, wait, what about this? Yeah.
Yeah. No. So there's a slight distinction there. So it's common area, but it's exclusive use typically.
Interesting.
So the homeowner has access to it. It's the homeowner's right to access it, barring other people from accessing it. However, it falls under the purview of the HOA or the COA, right? Because it's typically a condo.
Makes sense. Okay. See, even I learned something new every time on this one. That's really interesting. So the angle is the law exposes years of deferred maintenance and focuses transparency at the exact moment. HOAs prefer secrecy.
I think that's
escrow.
Well said. Yep.
Cool. SB 625.
Highly relevant right now.
Disaster rebuild protections inside HOAs. Effective January 1st, 2026, applies to homeowners in HOA impacted by declared disasters, fire, flood, earthquake. First thing that comes to mind is this is in response to the fires
100%.
Last year. Was it last year or was it late the year before? It was like right in that area.
Yes.
That horrible fire up in the Palisades area, Malibu, that whole area. I'm assuming this is in direct response to that. Okay, what the law does. Requires HOAs to allow homeowners to rebuild damaged or destroyed homes following a declared disaster. Number 2, HOA governing documents that prohibit or restrict qualifying rebuilds are void and unenforceable. Rebuilds must be permitted if they are in the same location as the prior structure, substantially similar up to 110% of the original size and height, and compliant with acceptable building codes. Really interesting. I'm about to cough.
Okay, cough, and I'll jump in. So, yeah, this is a response to the fires, in response to that tragedy. And really what Sacramento was attempting to do here was to remove typical roadblocks or bureaucracy, right? And it almost is a recognition of how slowly a board can move, or normally an architectural control committee.
Yeah.
So it's trying to lift those barriers to rebuild.
Yeah.
Because one, listen, you've already gone through this horrific event. You're fighting with an insurance company, most likely, on some level. You're trying to find a legitimate contractor.
Yep.
And I say legitimate because they're having a lot of problems up there finding legitimate qualified contractors, licensed contractors. There's a lot of fraud in that space. So this is at least, hopefully in theory, alleviating the burden of an architectural control committee saying, well, I don't love this, try again.
Yeah, it's already hard enough to get these permits and things from the city.
Okay. Or the Coastal Commission.
Or the Coastal Commission. Right. Good luck. Right. You already go through that, and then your HOA now puts a roadblock up. I mean, I love the fact that this has been put into place because it just removes another friction point in such a horrible situation. I think it's fantastic to try to move things along.
Yeah, and they also put something very powerful in this. It allows for attorney's fees if there is a roadblock. So if you have an HOA or an architectural control committee that's barring or trying to stop your build, and you force the issue, you tell them, hey, this is in violation of state law, and yet they continue to do so. And your hand is forced to bring on a lawyer to enforce your rights, maybe through court intervention.
Yeah.
Those attorney's fees are recoverable under this new statute.
So
that is powerful.
Yeah. They're really saying, please don't do this.
Exactly. And that's a powerful position. I mean, that is a direct homeowner empowerment piece of legislation from Sacramento.
Yeah. Super interesting. We've seen on the subreddit before that a lot of even board members watch this show and pay attention and participate in the discourse there on our subreddit. And I just think that it bears repeating that it's so important if you're a board member, and to your point, ignorance is not a defense.
Right.
That these laws, sometimes they think the end all be all is the CC&Rs.
Right.
This is what it says. But this now, your CC&Rs in this regard are null and void for those particular provisions.
Right.
Because state law now overrules it. I think it's so important for board members, and hopefully they've got good management company and counsel that tell them this, because they could cause some serious problems just by being ignorant of it. So
100%.
I hope the HOAs, I hope the good HOAs, and I hope any HOA adheres to this and understands what this means for homeowners.
Well, what's interesting too, if we talk about trends, you look at AB 130, and it took away the weaponization of fines.
Yeah,
largely,
which I love.
Same, of course. That was a big victory for homeowners.
And I think other states, I've seen rumblings of other states that might take up that same concept, which I love. So hopefully Florida, California kind of leading the way, because I think they have the most HOAs per capita. But
so you got AB 130, and that's de-weaponizing.
Yes.
This is very similar to that. This is a de-weaponization of a process.
Yes.
Because often if you see really bad rogue board members, the tyrants that we talk about, they'll use architectural standards, et cetera, to shut someone down, maybe just because they don't like this person.
Yeah.
And
or they have a power trip.
Whatever it might be, right? There's a lot of reasons. But this is, again, defanging a bad HOA.
Yeah.
So I think it was great.
Let me give you the conclusion. Boards used architectural rules as post-disaster veto power. SB 625 removes that weapon and makes HOAs pay if they try it anyway. So that's our conclusion there. Okay. SB 770, EV charger insurance roadblock removed. Effective January 1st, applies to homeowners and condominiums and HOAs installing EV charging station. What the law does, eliminates the requirement that homeowners name the HOA as an additional insured on their insurance policy. Homeowners must still maintain appropriate insurance coverage, but HOAs can no longer use insurance technicalities to delay approval. Such an HOA thing to do.
Yeah, arguably this is another one. I mean, whatever you think about electric vehicles, I'm agnostic to the idea of them.
Yeah.
But to the extent that you purchase one, you acquire one, and you need to set up a charger, and the HOA comes in and tries to shut that down. Again, through a technicality.
Yes.
And I've seen that play out so many different times.
Yeah.
This, again, is sort of taking that play away from a bad HOA. And again, can you imagine the frustration you have? You're just trying to install this thing. There's this technicality. And all of a sudden, you're in a situation where you're stuck with an electric vehicle that you can't charge at home.
Yeah.
Because Billy on the board just doesn't like you.
Yeah.
And is playing games. So again, this eradicates a potential leverage point against the homeowner. And again, I think you're starting to see this trend here.
Yeah.
And I think they did a very nice job with this SB 770.
Yeah. Yep. Okay. It's putting a button on that. So the hopefully faster EV charger approvals, fewer arbitrary denials, reduce HOA leverage over clean energy improvement. And it goes back to the state really has pushed a lot of legislation and to what am I looking for? Not enhance, but encourage clean energy, solar and EVs and all that stuff. And then to have the HOAs just put a roadblock, an arbitrary roadblock. The state's, I guess, has seen through it and says that's.
It's interesting because we speak a lot about how associations again weaponize or use different aspects of a homeowner's relationship to the HOA as a leverage point against it or a pain point, right?
Yeah.
And so slowly what you see is in 25 and now in 26, these leverage points are being taken away.
Yeah.
Which I think is phenomenal.
Yeah.
Whether it's EV or solar. And the next one actually is very much on point. 543, but we'll get to that in a second. But this is a trend. This is the shift that we were talking about. This is the shift we were talking about last year.
Yeah. So our conclusion on this, If your HOA has been blocking EV chargers with insurance excuses, that playbook expires in 2026.
Whoa.
I love
like how I
that.
said that.
Yeah. All right. SB 543, Junior ADU, and they another acronym, JADU, protections that override HOA resistance. Can I say I just love this one so much because of just the gamesmanship? The end of the gamesmanship. Okay. Effective January 1st, 2026, applies to single-family homeowners, including those in HOA-governed communities. What this law does, strengthens homeowners' rights to create junior accessory dwelling units, limits JADUs to 500 square feet of interior space, clarifies when owner occupancy rules apply. We'll get to that. Requires rental terms of more than 30 days, invalidates non-compliant local ordinances and HOA restrictions. Okay. Love this so much. Let's wind back to a couple, was it either 2024 or 25 when the law passed that allowed for ADUs? The exact law escapes me, but
so yeah, California became very bullish on ADUs.
Yes.
And the problem was obviously housing crisis, so they wanted to encourage housing.
Yeah, and specifically, a lot of it is like just for family, not to mention rentals and other things, but a lot of it is just family. Like my family can't afford, I want to be able to put a small structure on my property for them to live in. Right,
and historically, before that law came into effect, we had so many problems with associations barring ADUs.
Yeah.
Right? They were saying no because of this or because of that, or there was an outright prohibition on them.
Yep.
So California stomped that out very quickly.
Yep.
Okay? So that was great. And all of a sudden we were getting these things through. And if an HOA tried to stop or stonewall us, we could just plow right through. State law trumps, as you know. So this modifies it, or I guess expands upon it.
Yeah.
Now we're talking about junior ADUs. And so essentially what it does is it's saying that these homeowner associations are no longer able to dictate housing policy in the state. Because that's exactly what it was. It was a sort of attempt to control homeowners' rights to do what they want with ADUs.
When I read this, the first thing I thought of, those sneaky HOAs, they figured out some loopholes to block the ADU provisions that they just put in the laws. To me, when I read it, it was like, oh, they're just buttoning this up with things
100%.
like clarifying when owner occupancy rules apply, requires rental terms of more than 30 days, invalidates non-compliant local ordinances and HOA restrictions. To me, I read these things in there and it's like, oh, they're clarifying so there's no more gamesmanship of the HOA saying, well, that law doesn't apply because it doesn't apply to junior ADUs.
That's exactly what happened.
Yeah.
And so that's what I think the theme of this is, right? It's closing those loops. It's buttoning these things up. And it's refinement at the end of the day. We're refining these laws more and more because, of course, the bad associations, they're always trying to outmaneuver, outnavigate, and find an angle to come after a homeowner.
Yeah.
That's their nature, right?
Yep.
And so for the first time in a very long time, Sacramento is really saying, you know what? This is a problem. Let's tweak this. Let's modify this.
Yep.
And again, it goes towards homeowner empowerment, which, of course, for us and what we do in our advocacy, that's a win.
Yep. I love this. Okay, so the angle. HOAs don't get to invent housing policies anymore. State law wins.
There you go.
I love this one. Okay. I have a couple that those were the major ones, the four major ones that are passed in 2026. But I think it's worth just a couple minutes to kind of educate the people of what might be coming down the pipeline.
Okay. Yeah.
There's some pending HOA and homeowner relevant bills that are likely going to be voted on in 2026. They're not laws yet, but it's a good idea to kind of get people to understand what they are. And then, I mean, here's the reality: homeowners have sway.
Yeah.
They can call their local Congress person and then and try to say, I want this passed or whatnot. This is, I mean, it's
yeah, and some of them are still in development.
Yeah,
there's theories, there's broad strokes, but they're still in the refinement process.
Yeah.
So I think the two that we talk about today, assuming assuming that they're articulated and drafted correctly, could be very meaningful for the homeowner.
Yep. Okay, let's go with SB 677.
Okay.
HOA and CC&R restriction on housing development. What it would do would invalidate HOA governing documents provisions that effectively prohibit, unreasonably restrict housing development or urban lot splits on residentially zoned single-family lots. This just goes back to housing crisis
Correct.
and allowing more homes to be built.
Well, yeah, this one is really looking at the flexibility
Yep.
for the homeowner and allowing the homeowner with a little bit more, or actually much more, ability to do what they want with their lot from a housing perspective.
Yep.
And historically, you see these very arbitrary rules in the CC&Rs that really don't make any sense and are very anti-housing.
Yep.
And so this is looking to patch that hole.
Yeah. So why homeowners should care could significantly limit HOA control over lot configuration, additional units, and housing flexibility. Targets CC&Rs used to block state-mandated housing policies. So we'll see. That's SB 677.
Okay.
Okay. Let's see here. Let's go to SB 811. HOA CID document delivery requirements. What it would do, make changes related to how common interest development documents are delivered, why homeowners should care, could affect access to records, notices, or other official HOA communications. Since it's a spot bill, it suggests that amendments are still coming, but that's kind of an interesting one on communications. We've seen similar laws in Florida pass where they're required to have websites, emails, and all this stuff on how, and very plainly specify how some of the documents are accessed and communication is to take place.
It'll be interesting to see where the amendments land on this and what language is provided, because again, there is this new age approach where it says, hey, let's get these documents out there, let's make it transparent, let's allow the homeowner to get it very easily. A lot of it is moving obviously towards electronic distribution.
Yeah.
And so this one, seemingly, at least on its surface or on its face, looks like it's a step in the right direction towards transparency and towards access to very relevant documents.
Yep.
That historically, homeowners have had a tremendous struggle, needlessly or wrongfully, to access.
And we had a shameless drop to another episode on if you are having problems getting access to documents. We did an entire episode. It's like 45 minutes long on how to access what you're entitled to as a homeowner, what you're not entitled to, and how to access them if you're in California. Yeah,
that was a California episode. But again, if you're in a different state, call your local attorney. See if there's anything similar in your state.
Yeah. Okay. Let's go to SB 546.
I like this one.
HOA financial statement review limitations. What it would do would remove or restrict a board's ability to review HOA financial statements outside of formal meetings. Interesting. Why homeowners should care impacts transparency, financial oversight, and how quickly boards can act on financial information. Could affect accountability for budgets, reserves, and expenditures.
So again, going with this theme of transparency, what they're trying to do is trying to bring everything to the public, or at least the community, right? And so if you can limit sort of these types of sessions or ensure that they're made in front of potential homeowners, right? It cuts off that ability to operate in the dark.
That's where embezzlement happens. That's where a lot of
mismanagement.
Yep.
And so a lot of these new laws, these new changes, the conversations that Sacramento is having is, how do we remove all this dark, secret, backroom negotiations on these communities?
Yeah.
And again, that all goes towards homeowner empowerment and allowing or disallowing a bad HOA to continue to operate in secrecy, which is where they thrive.
Yeah.
So I'm very optimistic for 26 and as we move forward.
Yeah. So I think that covers all of the 26 ones. Oh, there's a few more out there, but they're very early and still trying to find their footing. Premature. So we didn't include them. Those are the ones that might be relevant to some homeowners, but some really exciting stuff that happened and good for homeowners to know, good for boards to know.
Agreed.
So yeah, excited.
All right. Very exciting. Well, again, Marty, Happy New Year.
Happy New Year.
Big year ahead of us. Indeed. And thank you guys for watching. If you like the show, be sure to like, subscribe, check out the subreddit. We have our new mascot who we...
Oh, Snoo. He's hiding behind here. Here you go.
There he is. All right. Thank you, guys.